Good morning, good afternoon, or good evening, depending on where you're at. I am Bob Mata, your host, and this is Defense Diaries. We are here for what we decided to call the Friday Roundup, the true crime roundup, because we're gonna talk about a few cases today. As you guys know, the world of true crime never sleeps. People are always doing horrible things to other people. So, needless to say, there is always something for us to talk about. So today I thought that we would examine a few different things going on. The first thing that we're going to do is take a peek over at Donna Adelson's last final pretrial hearing before her trial. I believe it's her final pretrial. Oh, hold on. It's something had started making noise. What it is? So that is going to be Donna's sound. Just so you guys know, it gets a little better. It sounds like they're sitting in a giant tin can. So, it gets a little better. It's not a matter of cranking it up. Um, I have checked both Law and Crimes feed. I have tracked our friends over at Trial TV Live's feed. Sound is the exact same on both. So, complaining about the sound, just gonna warn you now, will accomplish nothing. There's nothing I can do about it. It's not necessarily a boosting issue. If you guys tell me that you're having a really hard time hearing it, I'll boost it some, but it's just going to kind of elevate the tinniness. You'll see what I'm saying. It literally sounds like they're in a giant can, and they better fix this shit before her trial starts. Like this aggression cannot stand. Like they have to have better sound than this. Um, but I'm assuming that they will. I don't think that they have the full rig going. I mean, Charlie's trial was really good in terms of sound and camera work. So I'm hoping that it'll be the exact same thing over here. So again, Diz, do you know, is this her final pretrial? I believe that it is. There's some motion work in every case as it approaches trial. The judge always sets typically either a week, sometimes like in our neck of the woods, it's typically like the Thursday preceding the Monday that trial is slated to start because we typically start our trials on a Monday. They block out uh, typically a week for what they call jury week. So that is when everybody that got jury notices for all kinds of trials. And if you've ever been served with a jury notice, you know when you get it, 98% of the time, you have no idea what kind of trial you're going in for. Now, for some of the more high profile cases more recently, they've been sending out questionnaires to prospective jurors where they are getting a heads up on what trial they potentially could be sitting on. They're doing that in order to try to screen people on the front end as opposed to just leaving it all to voir dire once they get in court. But most of the time, you just get a jury duty notice, you show up to court, you sit in a big room with a bunch of other potential jurors, and they start sending you to different courtrooms. It could be depending on the courthouse you're in. Like in our area, most civil cases aren't even in the same courthouse that the criminal cases are. So you'll know whether it's going to be civil or criminal. And then once you get in the room and the judge has all the potential jurors in there, the judge will say, okay, this is the type of case it is. Does anybody have any issues just on the front end with sitting on a jury that's dealing with this type of case? And if people are like, yeah, if it's a DV case, domestic violence, and you've got a victim, they may be like, yeah, that's way too triggering for me. Plus, I'll be incredibly biased. You're not going to want me on this jury. So they'll deal with that kind of stuff. So on the back end, we get what they call the final pretrial hearings, and we're going to watch a couple of them today, which I believe are the final truth. Like the Laurie Shaver thing, which we're going to do last, is definitely her final pretrial, and it's interesting. That case is beyond warped. It's like every case that we watch, you're like, "Oh my god, can it get any worse? Like, can people be more horrible?" And then they just keep come just one after another right down the pike, just horrible people doing horrible things, and it's unbelievable. The Shaver thing, if you know nothing about it, I'm gonna give you a bit of a primer because I did decide we're gonna stream it, and it starts next week, so I wanted to make sure to be able to get, the primer out to y'all today, because it's always nice to go into a trial with a clue as to what the trial's about, what kind of the backstory is, and, I think the Shaver thing is going to piss a lot of y'all off. You know what I mean? It's not unusual in the sense that we've got a woman alleged to have killed her husband, but the fact pattern behind it is pretty insane. And what she ends up doing in terms of who she points the finger at, and I'm sure some of you know, down the road as the trial progressively gets nearer, it's something else. It's something else. It was a new one for me. It was a new one for me. And I've heard it all, seen it all. At least I thought I did. So let's start out with Grandma Gotti, as Jay likes to call her, or we could call her the Berserk Bubby. The marauding, murdering mum, any of those nice Jewish grandmother names, I think would fit for Donna Adelson. Uh, I'm assuming that everybody in chat has an idea who Donna Adelson is. She is the mother of Charlie Adelson, the mother of Wendy Adelson, two Adelsons that uh, Jay's convinced are both behind the nefarious scheme to end the life of loving father Dan Markel. Charlie was tried and convicted last year. Shortly thereafter, Donna, who is thought to be the puppet master of this entire night. Bob, Donna has a final docket call 912. Thank you, Diz. All right, so this is probably just the final motions. The final pretrial will just be dealing with housekeeping issues, making sure there's no issues before they start trial. We like to try to get into these trials, running with a running start as opposed to limping in. That's why we always have these final pretrials. So, but again, this whole scheme that was put together by Charlie and allegedly Donna and probably Wendy. We'll find out. We'll find out if she's going to get charged. Jay is pushing as hard as he can. There's a lot of people out there that are really hoping that Georgia Kappelman, that she rests her next. I don't know whether it'll be her or Harvey. Harvey might be the toughest of them all, like in terms of, yeah, like Harvey is like a knowledge guy. Like I have zero doubt that Harvey was not walking around completely oblivious to what was going on around him. I think that Wendy's case, which I still think is a tough case, and Jay has done some yeoman's work in terms of trying to prove to me that they have enough evidence. Like there's two different things, in the law, in terms of trials, in terms of people being arrested. There's knowing somebody did something, right? And then there's proving that somebody did something beyond a reasonable doubt. Those are very, very different things. For instance, if you followed this, if you listen to my first season of Gacy, the whole thing with Gacy is that his last victim, it was so obvious what happened to him. The kid was working at the pharmacy. His mom, it's her birthday. She comes to pick him up right around when he's supposed to get off, 9 p.m. on December 12th. Kid's like putting his jacket on as his mom comes in. She passes this guy as she's walking in, two ships passing in the night. His mom says, "Mom, I gotta go." He says to his mom, "I gotta go out and I gotta talk to this contractor about a summer job." And she's like, "I'll be right back." And she never sees him again, you know? And obviously, Rob Peace's mother knows,
Well, she goes to the like, as 2 hours go by, she's like, Where's my son?" And this is in 1978, so this is long before cell phones and texting and, all the ways that we can communicate now. This is, "My son's just vanished off the face of the earth. Where is he?" Goes in, talks to the pharmacy owner. "Who's that contractor that my son went to talk to?" "Oh, that's John Gacy, good guy." She's like, "Oh, okay." Proceeds to get in her car, drives over to Des Plaines Police Department and reports her child missing immediately. And she's like, "Nah, nah." Like when they're like, "Yeah, he's probably just out with friends." She's like, "Nah, no, none of the things that you're about to tell me that you said about, all these other kids that go missing. And that's not my kid. My kid vanished. It's my birthday. I came to pick him up. Said he was going to talk to this contractor named John Gacy. Boop. There it is. So they actually, Des Plaines PD goes and gets a warrant for the next day. They're out at Gacy's house, searching Gacy's house. They don't find anything that connects Gacy to Rob Peast. Like during the entire search, they get down in the crawl. They don't smell anything. They don't see anything unusual. They're going around the house. They find some weird shit. Find like a class ring with the initials JAS on it. That's obviously not Rob's class ring. They don't find any of Rob's clothing. All the things that they list in the warrant, they don't find any of it. So they're they're stuck, right? So that's when they start the whole 10-day 24/7 tail on Gacy, and they can't get anything on him. Like everybody knows, Kozenczak, the lieutenant that's heading the investigation, he knows that this guy did something with Rob Peast. Rob Peast's mother and family, they know, but they didn't have any evidence to get him under arrest. Gacy's not an idiot. He's not killing people while they're tailing him 24/7. My point being, law enforcement can know that somebody did something in their heart and in their minds, but just not have the evidence to be able to bring it into court and prove it. So that's my concern with Wendy. I mean, there is certainly powerful circumstantial evidence that she knew, at the very least, knew that it was going down. But is that enough to get her on a conspiracy to commit murder and murder? That's the $1,000,000 question. I mean, there's certainly charges that can be levied against her shy of that, but that's that's not what they're looking for. They want her going down just like Chuck and the murdering mum over here. So, all right, let's get started. I'm gonna warn you, if you're late to the party, the sound on this particular hearing is brutal. Okay, it's very tinny. So there's nothing I could do about it. I have the sound booster. If you guys want me to boost it slightly, I'll do that. In terms of checking I've checked. I, I found 3 places that were airing it, and the sound wasn't good on any of them. So, hopefully they'll have the captions. I don't know if they have the captions. It's not showing as available here, but I mean, let's check it out. Let's check it out, and let's see what exactly Grandma Gotti, the murdering my mom, the berserker Bobby, has up her sleeve. Let's see what she's gonna file today. See what she's gonna argue. All right. Let's check it out. There she is. Look at her. Looking older, huh? Whew, that jail time. That'll do it. That's that'll do it. That'll age you. That jail time and being the president. Those are the 2 things that age you the quickest. Well, how about that sound? We're gonna watch with our homies over at Trial TV. Whew, bad. That horrible buzzing sound. It's moderately better. Here, I'm gonna bloop it till we start yapping. There's Georgia looking quite lovely, ready to tear some throats out. She's ready. All right, let's see if they're talking.
Sir Captain Dugan, state.
Oof.
Dan Rashbaum on behalf of Mrs. Adelson, who's present.
There's everybody's favorite criminal defense lawyer, Rashbaum.
Very well. Let's go ahead
Good.
and move with the one hearing that was scheduled for today. This is the 2-minute motion in limine concerning the testimony of Sergeant Corbett and the summary exhibit. Whoever's arguing the motion may proceed. You may.
Judge, I think we filed pretty detailed papers on this.
Thanks, Jay.
So I'll quickly summarize, and then if you have any questions, I'm happy to answer anything that you have. I think it's really important to realize we're not asking that he not be allowed to testify. What we're asking for is 2 pieces at this hearing, and there'll probably be more during trial regarding actual pieces of his testimony. So that's the 3rd piece. The first thing we're asking for is that he not be qualified as an expert.
Now, I'm not ever one to body shame anybody, but this dude, he's got an impressive waddle. Yeah. That side waddle. Oof. I don't know what exercises you do to get rid of waddles, but
We don't believe, as set forth in our papers, that he's testifying to anything that meets the standard of Florida statute 90.956.
sound gets a little better.
And so we don't think he meets the qualifications of an expert in what he's testifying to.
You mean 90.702?
I'm sorry, 90 point.
Oof. Everybody with the sound.
We don't think he meets those qualifications. We think he is a summary witness, not an expert witness, and we think his report illustrates that. The report itself has essentially 5 components. It has emails, which are a culmination of emails that the state has taken and put in a report. Text messages, neither of which emails or text messages is he an expert on. He's just compiling them, putting them in a report. Video surveillance photos, and then it has call record summaries, which we'll get into, but takes no expertise to do the call record summaries. Florida law is pretty clear on that, as well as cell site data, but it's very limited to cell site data, especially with regards to Mrs. Adelson, who's on trial here. There's some more detailed cell site data with regards to Mr. Garcia and Mr. Rivera, but even that wouldn't qualify as expert testimony. The cell site data as to Mrs. Adelson, there really is virtually none of it. So
One question before we continue on the track of the expert testimony. As it relates to...
All right. So again, the sound's going to suck, but can you hear it? Can't improve the quality. I can boost the volume though. Like to me though, if we boost it, it's just making the horrible noises louder, but y'all are the bosses. You guys tell me.
items that the state can properly admit. And I'm sure that based on your pleading, there are aspects of the current PowerPoint that are disputed as being inadmissible. But for what can be properly admitted, are you also disputing that those cannot be used as a demonstrative during trial by the state in some way?
no, they can be. So in other words, there's no dispute that they can use the report as a demonstrative. There's no dispute that for the admissible items, they can put in the admissible items. So I'll give you an example. Email between Wendy Adelson and Donna Adelson. Clearly it's admissible, provided it's relevant. The ones they provided are relevant. Clearly admissible. The underlying email can be admitted, shown to the jury through an appropriate witness, if they call Wendy Adelson, for instance.
Boy, the closed caption
that email
sucks.
is admissible. But the summary of the email in the exhibit, the summary of the 1 or 2 page email in this exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. Does that make sense what I'm saying?
It does.
No, I cannot control where the closed captioning pops up, that's where it is. There's nothing I can do about that. I don't think I'm fairly certain. Jay, there's no way to move closed captioning, right? It kind of is where it is. Let's see. It would help. Can you guys not read it? It's right in the middle of the screen. Like you're not missing any of the bottom of it. Like but and for the record, you'll start like who's ever doing the captioning is brutal. Like they're butchering words left and right. So it's going to give you half the story. So you're going to have to piece it together by the distorted sound that's coming out and the half truths that are being written in the closed caption. It'll be fun. We'll do the best that we can.
And the one thing I the only one thing I would question, even concerning demonstrative, are you also saying the state cannot put the context around these various pieces of evidence?
No, they can.
Never said
Right?
governor.
They can make arguments just like they do in closing arguments. Right? They can show the exhibit to Sergeant Corbett. He can put it on the screen. He can explain whatever he's going to testify to. Our argument is he's not an expert in doing that. That's our first argument. And our second argument is ultimately that 329 pages right now doesn't go back to the jury. It's a closing argument, essentially. When you look at his 329 page exhibit, and again, I'm getting a little ahead of myself, but when you look at his 329 page exhibit, it's essentially Ms. Kappelman's closing argument. Okay, which we don't admit to the jury. The jury doesn't get her slides and see them in the jury room when they're deliberating. But no, of course, they're able to, provided it's admissible material in it. They're allowed to show the exhibit. They're allowed to use it as a demonstrative. They're allowed to question Sergeant Corbett. He is allowed to be a witness based on what he did. Our argument is, number one, he's not an expert, and number two, the actual exhibit is not an appropriate summary exhibit that would go back to the jury during deliberations. That's what our memo is about, and it's supported, Judge, by Florida law. So the Florida Supreme Court has held that law enforcement testimony, which merely summarizes and explains data from cell detail records, including the mapping of cell phone location data, is not expert opinion under Florida Statute 90.702, and Daubert, because it involves no scientific, technical, or other specialized skill, cites King v. State 260 SO 3D 985, Florida 2018, McMillan v. State 214 SO 3D 1274, Florida 217. The Florida Supreme Court has supported that, and also has the 11th Circuit in Batista, B-A-T-I-S-T-A, in affirming the Florida Supreme Court, where the 11th Circuit of Court of Appeals affirmed the district court's decision to admit as lay testimony an FBI agent's use of cell phone records, along with the phone company's records of where their cell phone towers were located, to plot on a map which towers connected with which cell phones at a particular point in time. But it said it wasn't expert opinion. It said that you don't need the agent doesn't have any expertise to read the cell phone records to determine which cell tower was used at a particular time, look up the latitude and longitude of that cell tower in the company's records, and mark the intersection. Yeah,
he's 6'5". That podium is like a giant podium. No, he's a little dude. He's a little dude. I mean, he's not like little people, but he's a short guy. I'd guess 5'5", if I had to.
Of the latitude and longitude on a map. That's precisely what Sergeant Corbett is doing here. It is exactly on point to what he's doing here. Also, the fact that he pulled data off of iClouds and he pulled data off of iPhones, it's not expert. Now, of course, he's able to testify to it, but it doesn't meet the standards of expert testimony. Now, moving to the second point, Judge, which is whether...
Before you move on to that, when it comes to the data pulls, because I've heard this argued, not by you, but a number of ways over the years. The first being the data pull itself is a factual issue, which I would agree. How the machine works and whether or not the data pull was in fact, it took place technically in a correct manner, that goes to more specialized information. Is there going to be any contesting of any way that the data pull was somehow not technically proper or sufficient? Because if so, at that point, now we are veering into a matter that deals with specialized information, knowledge, or expertise.
Judge, may I have one moment, please?
Go ahead.
Yeah. So, I mean, basically they've got this witness coming on to testify that he's the one who pulled the data, right? And I don't know if Adelson's defense team's like concept is that they're going to try to attack the data by saying that it was planted or that law enforcement tinkered with it or that they can't prove that it was emails and text messages between Donna and Wendy or Donna and Charlie or Donna and Harvey, whoever the case may be. I mean, clearly this witness is going to be able to come on if they're the person that pulled the data is going to be able to put the data up in a demonstrative piece of evidence and read through it. I mean, we see cops do it all the time, and they're not necessarily expert witnesses in retrieval data from phones or forensic guys. So, like, I don't know. We'll see where this goes. It's not a very powerful argument by Donna's team here.
Stipulated to that.
Whoa,
That's one of the things you stipulated to.
Georgia.
All right, so we'll have
Talk
to
about stipulating things.
Okay.
Judge, I don't believe it's going to be an issue. But we understand what you're talking about. If it were to become an issue, then obviously the expertise on that particular issue would be obviously subject to his qualifications, which we think he has. Okay, but at this point, we don't anticipate it being an issue. We don't anticipate. There may be questions as to why he pulled it as opposed to someone else pulling it. But as far as whether it was pulled appropriately or not, we're not contesting that.
So what's your beef?
Okay, so Judge, if I may just move on to the second part of the argument. The second part of the argument is not dependent on the first. So whether he's an expert or not an expert, it really is an independent inquiry, the second part of the argument, which is whether ultimately whatever turns into his exhibit, his demonstrative, goes back to the jury. And again, for purposes of today, unless you want to go into it, I'm not going to be talking about specific pages that we don't believe are admissible. So let's just talk about the thing as a whole, if that's okay with the court.
So he's trying to argue, well, what he's arguing right now is that whatever they're going to be putting up, and we see it all the time in trials, Jay and I are always bitching about it, like, oh my God, we can't read it, blow it up. They're going to be putting up the demonstrative evidence that has the body of the text messages or the emails. And so he's arguing whether or not that can go back to the jury when they're deliberating. I think that that's what the argument is here.
So, Judge, this summary, and I think you had an opportunity to view it. It's not, the first thing to understand is it's not a neutral summary. That's the first thing to understand. The second thing that alone does not end the inquiry. It's just a fact.
Well, to that, and obviously a criminal case is different from a civil case, but all the time in civilly litigated matters, parties will have presentations, reports, summaries prepared. The plaintiff, by nature, is adverse to the defendant. Anything that they're preparing for the jurors is going to advocate or in some way demonstrate why I should win. As it relates to this summary, the state is prepared with, in anticipation of litigation, to advocate their position. Why is this inappropriate?
That alone, that fact that it's not neutral, is not the determining factor. But it's one that courts would tell you to look at in deciding whether it is a summary that's appropriate to go back to the jury or whether it is more in line with a closing argument, which would not be appropriate to go back to the jury. So I start with that just because it's just as a basic factual point. I don't think it's determinative of your decision. What is determinative of your decision, though, is when you look at this summary, it's full of items. Again, we're not disputing that the items are admissible. Let me be clear on that. So the summary has, for instance, I think at last count, 30 to 40 emails. Those 30 to 40 emails, provided they survive evidentiary challenges, are admissible. But a summary is done for the purpose of taking voluminous records and synthesizing them in a way that helps the jury. That's what the statute talks about, right? And that's what the case law.
I mean, Rauschbaum put on weight, right? Like, has he been sitting around just like housing Boston creams? Like he's stress eating, I think, maybe. I don't remember him having like, or maybe there's just a really bad angle. We all have bad angles.
Talks about. That's what Oloyede talks about, which is 933 F3rd 302 310 4th Circuit 2019, where it talks about how we don't send closing arguments back to the jury.
True that.
That is not admissible under law, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence. Care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. So in this document, you see a bunch of items that are not voluminous. They're one page. Rental car agreements. There's no summary needed for that. 2-page emails, 1-page emails. There's no long emails. 1-page text messages. Not necessary. And then you see call records, and you see some call summaries. Again, not voluminous materials. I wish they were, but they were limited in what the call materials were. So, Judge, our argument is that the exhibit itself can be shown. We're not arguing that it can't be shown to the jury.
As a demonstrative, but not as admitted evidence.
Admitted evidence. The underlying evidence in it that's admissible can be admitted, obviously. Now, within the summary, and I think this may be better taken up at trial.
All right. So just so you guys understand what he's saying, he's arguing that the demonstrative evidence can be shown to the jury. Okay. In terms of the state putting their case forward, being able to have the jury view the emails and the texts and whatever communications that they have. But he's arguing that that cannot be admitted into evidence. The difference being things that are shown to the jury during the trial itself, but not admitted, can't be brought back and reviewed by the jury during deliberations. That's a difference.
Or in another day, unless you want to take it up now. Within the exhibit,
hold on. As to any pages that are specifically disputed as inadmissible, it's best to handle this outside of the presence of the jury, so that way it's clear what is in and what is out when all of it is ruled on.
Yeah, so I mean, we can do that at your convenience. Look, the state has still been updating it, so things may change, but we already see some pages that are either hearsay or privileged under the joint defense privilege, for instance.
True that.
There's not a lot, but we already see some pages that we think are problematic, and we can take that up whenever you want. But our argument today summarizes on his characterization as an expert, and either way on the document actually going back to the jury.
Let's handle that part of it then next Thursday if there are still disputes as to individual pages, so that way it can be handled and ruled upon.
Okay. Thank you, Your Honor. If you don't have any questions, we'll rest on our papers.
Very well. State, you may respond.
Get him, Georgia. Everything that guy just said is bullshit.
Morning, Judge.
Good morning.
Not even Georgia.
So the defense motion argues that, you don't have to be an expert in order to testify to phone evidence. And they cited the King and Gordon cases in their motion and talked about them this morning. I think it's important to consider that in both of those cases, which were post-conviction motions, where the court said that the defense was actually not ineffective for not getting their own expert, or not objecting to the witness testifying for not being an expert. The defense did not object to a non-expert law enforcement officer testifying to the cell phone evidence in that case because it was a strategic decision. The defense knew that they could cross the law enforcement officer more effectively than an expert, and the state could easily get someone more qualified had the defense objected. In Gordon, the court said that the witness from the phone company who testified would have qualified as an expert to testify to that data and been able to testify to the cell site data had there been an objection. In King, in that post-conviction evidentiary hearing, the defense put an expert on the stand who provided expert testimony on.
Oops, I totally butchered it. I was going to pause it because I was going to tell you guys two things. One, that's not Georgia. That is mini-me, Georgia. That is the future Georgia. She appears to be much greener, maybe. Seems like a good attorney, though. Jeez, how far? Okay, so I'm going to figure I was about there. And you guys are crushing the light game. That was really what I was going to pause for. You guys are crushing the light game. Thank you. Thank you for doing that. Sarah sounds right. All right, let's see if I got us back to the right place.
Said that the witness from the phone company who testified would have qualified as an expert to testify to that data and been able to testify to the cell site data had there been an objection. In King, in that post-conviction evidentiary hearing, the defense put an expert on the stand who provided expert testimony on GPS and on cell phone location data. The defense expert concluded that the defendant could have been at home, not at the crime scene at the time of the murder. So in that case, there was an expert who testified to the location information from the cell phone records.
That does lead me to my first question concerning Sergeant Corbett. What exactly is he going to testify to beyond what the cell phone data history records or cell phone tower records would show? That otherwise you need him to testify through an opinion that he cannot just testify off the records themselves.
Yes, sir. So he's going to be, and I have this in just a second, but as far as the summary goes, he's not testifying as an expert to everything in the summary, but he's testifying as an expert to a large part of the summary when it comes to cell site location data and how far, who's using a handset at the time and how far the person is from the cell site location. He uses more.
So you're saying how to interpret that data?
Yes, sir. And he uses more than just cell phone records to do that. But the cases, the Gordon and the King cases, those cases say a witness does not have to be an expert to testify to some of that information. But they're not saying that you cannot present an expert to offer an opinion on a handset's location if that witness has the necessary training and experience, just as was done at the hearing in the King case and could have been done at the trial at the Gordon case. And Sergeant Corbett has hundreds of hours of training and experience and has offered an expert opinion well over 100 times in circuit court. The reason they don't want him to be able to declare an expert, they don't want him to be able to offer an opinion. And this is more than just a data pull of, hey, we got these cell phone records. And this is more than just, this is where the cell site locations are at any given place in Florida. This is him forming an opinion on how far a handset is from a location, who may be using the handset at the time that you need this specialized, or that it's beneficial for the jury to hear his specialized knowledge because he's able to interpret the cell phone records to tell us that information. The defense also argues in their motion that there's basically just too much evidence in this summary, that it's more than just for phone records and some of the evidence isn't voluminous. But a summary's whole purpose is to summarize relevant evidence. Sergeant Corbett, as I said, is not offering an expert opinion on everything in the summary. He's offering an expert opinion on the interpretation of the cell phone records, the location of the handsets, who may be using the handset at the time. And there's a large part of the presentation that are those things, but there's a lot more information in the summary, like surveillance video from.
Sounds like the horrible buzz of that tube lighting. Like what the hell? I think every place uses like LED now, but those like does look like they like that's what it sounds like, that buzz that you used to get from the hell did they call those long tube lights that would buzz, drive people insane in work environments. Those fluorescent, thank you, CH. That's what it sounds like to me. I don't know what it is. It's annoying as shit though.
Premier Gym, a traffic ticket received by the suspect, a car rental agreement, that maybe those things individually aren't voluminous, but they're all material to the presentation and material to his opinions, because he's using them to provide an opinion on who had the handset and where the handset was at the time. For example, if a certain suspect's phone is communicating with a cell site that's consistent with like a car rental company, an expert may be able to better determine who was using the handset at the time and confirm their actual location and confirm the reliability of the cell site information. If we're able to see that, well, that person actually got a rental agreement at the time, they got a traffic ticket shortly after the car was rented, all of those things help him form his opinions and determine that. The defense says, this is a closing argument. The information that he looked at in this case, there is so much digital evidence that it is very all-encompassing. However, there's not what's in the presentation is not. It's all data. It's messages. It's emails. It's different business records and cell phone records that we received that helped inform those opinions. They talked about the 30 or 40 emails. When I'm handing them over the things that I may use in my presentation, I'm trying to be as thorough as possible. I don't want them to have less information than I may use. I don't intend to use all 30 or 40 emails. I don't intend to have Sergeant Corbett sit up there and read all of those, but I wanted to send them all of the ones that I may use, as far as just, these are what was found in these different accounts. This was and asking him, hey, did law enforcement find some evidence of motive that caused him to look into these people? Yes, X, Y, and Z were found. Maybe spend 3 minutes to 5 minutes on that and move on to the next thing.
As to that point, and I believe the defense's motion hits on this as well, for what you have asked Sergeant Corbett to add to this, is that in fact his opinion?
So the defense motion attacks that, the prosecutor is ultimately deciding what's going into the presentation. Maybe that's what you're referring to.
Yes.
But Sergeant Corbett's job is to pull information from these devices, interpret that data from the cell phone records. He's not investigating or prosecuting the case. In the investigative phase, he has to rely on the investigator to let him know what he's looking for, what this proverbial needle in the haystack is, whether he's wondering it exists. And Sergeant Corbett's then looking through the records to see if there is one, and then if there is one, including it and letting them know. Sergeant Corbett doesn't know exactly what the prosecution wants to present at trial. I talk to him about what the records show. I ask questions. He looks for answers. He lets me know what the data says. And then I'll say, yeah, can you put that in there? I think that's important. He's not the one talking to witnesses. I may talk to a witness. They tell me a certain event occurred. Then I go back to Sergeant Corbett and say, hey, is there any evidence of X happening? And he lets me know that may corroborate what the witness says, and then we're able to put it in there. And I'm not able to get that information in any other way, because he's the person that's looking in these cell phone records and can let us know whether that evidence is corroborated or not, and can provide an opinion on what the data shows, where that handset was at the time, how far they were from the tower at the time, things that may corroborate witness testimony or appear in the cell phone records that I wouldn't be able to see or know on my own. The defense motion also argues that the summary isn't admissible, but summaries are admissible. That's the whole point in using them, and there's no case law that I know of that says otherwise. that a summary isn't admissible. It has to only be used as a demonstrative, and the defense doesn't cite any either. The defense has specific objections to certain slides because of hearsay or privilege or other things, which I'm ready to discuss at any time the court is. But as far as the summary not being admissible, there's no case law that I know of as to that. And the defense hasn't cited any either. That's all I have.
Very well. One question about the document itself. And I think this is really what goes to the heart of the defense's motion about the summary. If you're taking, say, thousands of pages of documents and you reduce them to, let's give it an arbitrary number, a 25-page report, you have synthesized the larger to the smaller into something that is digestible for the jury to use in making their decision. That, or at least according to their position, is not argumentative. Some of these things are more or less a part of the state's summary, at least as it stands right now. It's showing corroboration of other evidence. Is that in fact a summary in the sense that the statute defines a summary?
Yes, sir. I mean, this is the things that may corroborate other evidence, though, help this expert form his opinion.
Yeah, it's almost as if the person that's typing in the captioning themselves is hard of hearing. Like there's so many mistakes. It is quite hilarious to read the captioning because it's like reading a novel that has nothing to do with what we're watching in court. It's amazing. Watch and learn. Hey, I don't know if Tracy K's in here, but I saw in the Discord, I got a message. It's Tracy K's birthday. Happy birthday, Tracy K. If you're not here, but you come later, happy birthday. We love you. I hope you have a wonderful, wonderful day.
The example I gave with the traffic ticket and the rental agreement, he's able to, from the phone records, say this phone is consistent with this cell site at the time. They may be this far from there. But as far as showing who has the handset at the time, like who's talking on it, and how far they are from it, it's all of those other evidence that helps him form his opinion.
Very well, thank you. Brief response, if you have one.
Really brief, Your Honor, and I just want to make this clear, and I think you understand our position perfectly. We're not arguing that summaries are not admissible. We're arguing that this is in the proper summary. That's the argument. We don't make an argument in our papers that summaries are not admissible. We're saying that this document doesn't meet the foundations of the Florida statute as a proper summary. Again, they're taking particular points, but these are not voluminous documents that they're now summarizing. So there's only one voluminous document that they're summarizing in this entire presentation, and that's how they got originally to Harvey Adelson's phone number, where they had data that would go to the ceiling. If they wanted to do a summary exhibit on that piece, it might be allowed. But everything else is not voluminous materials. It's a closing argument. To allow them to put that document to the jury would essentially be the same as saying, you know what, Ms. Kappelman, Ms. Dugan, when you do your closing, the PowerPoint that you do, that should go back to the jury too. Because it's essentially the same thing, Your Honor. There's no difference. That's all I have, Your Honor.
Well, concerning this motion, I'm prepared to rule
bro.
as to whether or not Sergeant Corbett can be properly qualified as an expert witness. I will find if Sergeant Corbett is capable of testifying to the interpretation of the records that go beyond just merely where the towers are, what was pinging, and what the phone records show, that would go to scientific or technical expertise in which he is properly able to give an opinion. As to the summary itself, and I do not want to belabor this point, but I do believe I am going to need to hear from Sergeant Corbett specifically as to how he put this together and his opinion was informed by the information that is in the summary before I can rule on it. Otherwise, I agree with the defense position. This is proper as a demonstrative, but to admit it as evidence, I'm going to need to hear more. We'll have part 2 then, in which Sergeant Corbett can testify concerning how the summary was created and how his opinions were formed by the evidence that are within the summary after we have the docket sounding next week. As to another matter in which I am prepared to rule on at this point, concerning the defendant's motion in limine, concerning testimony from Wendy Adelson as to the storyline of her book and also changing the names of the children, I will permit the state to use this information for impeachment, depending on what is developed during the examination of Ms. Adelson. As to the other matters concerning her testimony, that has already been ruled upon. Has the state also decided which jailhouse recordings you're intending to use for evidence? Because I did need to review those.
Yes, sir. As of right now, we do not have any jailhouse recordings that we intend to introduce that feature Mr. Adelson, which is what the defense was objecting to. So that's why we have not sent any to your honor. May I clarify what you just said about the name changes?
Go ahead.
You said it could be used for impeachment. May I? She admits that point, or has previously. Would I be permitted to inquire about that area?
As it relates to any prior testimony she's given on the subject, you may inquire as to that. Very well. I believe still outstanding.
Judge, I'm sorry.
Go ahead.
I just want to make sure I understand now. So our motion was to prevent them from inquiring as to the name changes. So in other words, our motion was Ms. Kappelman or Ms. Dugan can't ask her the question, did you change the kids' names? That was what our motion was. So I'm just not sure the ruling. Can they ask that question?
Well, on that particular point, what is this being offered for, Ms. Kappelman?
For motive, Judge.
As it goes to motive, I will permit it for that reason, or also impeachment, depending on what comes out. Motive and bias are equally available for both parties to explore.
I mean, that's only going to become an issue if she testifies, Donna, right? I mean, I don't know who else they'd ask that of. In terms of, like, if they're trying to prove motive with it, you can't put like a clerk of court on to say, oh yeah, I took the document in and scanned it in and put it into the system, and I can verify that this woman came in and did a name change. Wendy, whichever one. Oh yeah, well, you can definitely ask Wendy. They could definitely, but like if it's Wendy doing it, I don't know how strong that is in terms. Yeah, I think Wendy's definitely getting called again. I think I don't know, man. It's like the more trials they have, the closer they get to arresting Wendy. I don't know how much they want to keep putting. I mean, the more they can get of her sworn testimony where she's just contradicting herself all the time and just telling lies that they will be able to impeach her on, I'm sure they're going to call her if they have every opportunity. And she has never once, at least not that I'm aware of, taken the fifth. So she testifies. Oh yeah, Diz says she has to testify because of her special immunity. So essentially what he ruled on the issue with the demonstrative evidence is he needs to hear the testimony of the cop and that he'll take it as it comes. I think the defense's argument is that they're concerned that when they send back, a 25-page summary of thousands of pages of messaging and emails and things of that nature, they've cherry-picked it, potentially taking things out of context, things like that. So the judge basically reserved ruling on that until after he hears the testimony.
All right. As to the state's motion in limine, I believe there is also one other outstanding item to be addressed concerning Luis Rivera's gang affiliation. As to this particular point, and I've researched this further, Mr. Rauschbaum, as to the name of the organization, I'm really failing to gather why hearing I was threatened by a gang member versus I was threatened by a Latin King member is going to in some way create a greater credibility in front of the jury for the narrative that you wish to weave. I will permit Ms. Adelson, if she testifies,
You guys see that one
she
in
acted in
front
accordance
of
with being
June?
threatened by a gang member. The specific name of the gang, I don't believe in any way is going to assist the trier of fact in terms of assessing her story, whether it's credible or not. They will make their determination if they believe this testimony. I believe that was the only other outstanding matter of the state's motion in limine. As to Jeff Lacoste, I have not finished my research yet on that matter, but I will rule on it before we start with any selection of the jury. Do the parties have any other matters that we need to address this morning?
Yes, sir, just a second. Judge, in contemplation, like a planning when to start evidence, can we all agree that we would not start the presentation of witnesses until Friday, the first Friday?
Assuming that we have the jury selected by Thursday.
Yes, sir.
Well, that would probably be appropriate. Does the defense have a position concerning this?
You have 1 moment.
Go ahead.
That's fine, Your Honor.
Very well. Assuming we have a jury by Thursday afternoon, we would start with the case on Friday. Well, would the parties be able to go to their openings, assuming there's enough time Thursday afternoon?
Yes, sir.
Mr. Rushbaum? Very well. If we have enough time then, after we have the jury selected and sworn, we would give openings and then launch into the testimony from there with all the witnesses. Does the state have an idea, at least in terms of days, how long you think the case in chief will last?
I think 6 to 7 for our case in chief, Judge.
Wow.
All right. Does the defense have any idea at this point?
I would say, it depends, obviously, but I would think 2 days.
Very well. Nothing is going to be held fast and firm to this. I'm just asking for an estimate. One other matter to address with the defendant directly before we finish this morning. Ms. Adelson, next week we are going to have your final pretrial. That is typically the hearing in which I inquire of both parties if they are in fact ready to go to trial, if any continuances are necessary, and also information concerning plea offers. As I stated to you at a previous hearing, I do not prod people to take pleas. However, if you wish to consider a plea offer from the state, the time is rapidly coming for you to make that decision as to whether you desire to entertain any plea offer or not. If you want your counsel to provide an offer to the state, also the time is coming very close to a conclusion for them to do that as well. I'm not going to prod you either way, but I want you to be mindful of the fact, once we begin jury selection and the denial is sworn, that means trial has started. From there, basically because of count 1, if you are convicted as charged, my hands will be tied concerning any sentencing on that matter. Your attorneys will have further discussion with you concerning this, but if you are considering anything at all, you need to make a decision on this quickly. Do you understand where I'm coming from?
Yes, I do.
Very well. We are in recess. I will see everyone next week at 9 o'clock, September 12th.
Judge,
Yes, sir.
maybe briefly go sidebar.
Yes.
Sidebar. Why are they sidebarring with no jury in there? It always irritates me. All right, I'm gonna bloop. Oh, there's Donna, looking like shit. Oh, it's a good shot of her right there, huh? All right, that's that. Goodbye, Donna Adelson. All right, so that thing is going. That train is leaving the station. So final pretrial next week and trial time. Wow. Georgia guesstimated, she say 6 to 7 days or 6 to 7 weeks. Anybody hear that? Like which one was it? Did you guys catch that? Oh, geez. That means I might be in London for the whole trial. Wow. That's a bummer. All right, we're gonna move on to the next horrible, horrible case. And so you guys have any questions on what happened there? So a bunch of motions in limine were heard. Judge made rulings on a few of the issues, tabled a couple. Bottom line is, like, and again, remember, if you guys were on the live yesterday, we were telling you motions in limine are basically talking about things that you can say and not say, and things you can introduce and not introduce. It's usually limited at trial, things that are limited to that. Like it can be as minute as you heard, um, mentioning the actual name, the Latin kings of the game, because Rashbaum believes that gives the story more credibility as opposed to just saying a gang. You know, everybody's heard of Latin kings. Ooh, Latin kings. Oh shit. Yeah, right. I'm so excited. So excited to go to London. I'm ready. Ready. First time over to the UK. I'm really excited about that. Kai, you out? Thanks, Kai. We'll miss you. We'll miss you so much. All right, you guys. So we're gonna do. I think everybody's probably aware at this point about the most recent horrible school shooting that took place in Georgia at Apalachee High School. 4 victims. 14-year-old shooter. Kid's name is Colt Gray. Ironic name, unfortunate name. And like immediately I went to like the Colt 45 weapon is what I think. As soon as I hear it, I'm like, wow, just brutal. Like I said, there were 4 victims. We had 2 sweet kids, 2 loving teachers that lost their lives. I want to bring these pictures up of the victims. And this took place very recently. Ooh, am I frozen? All right. I just choppy on my end. I'm like frozen. All right, let's see. So I'm working for y'all. Yeah, on my end, I'm like super. Yeah, cutting out a bit. It's weird. I don't know what's going on with my stream. Got the worst internet. It's so annoying. All right, Dizzy, stay in studio. I'm gonna leave studio. I'm gonna come back in. All right, y'all just hold for 1 second. For 1 second. Like I'm super, everything's choppy. Like everything I'm trying to do is choppy. So I'm gonna leave and jump back in. I'll be right back. All right. So I think it's better. Maybe. Hopefully it's not choppy anymore. All right. So let's see. I feel like there's something going on with the internet though. Weird. It's annoying. It's either that or the hey, what's up? Spitfire? Okay. Share screen here. Yeah, I am not operating properly back here at all. Like everything is super delayed. I'm trying to think of what I should do. I don't know if I wish I could get Allie to jump on to keep y'all company while I feel like I need to maybe reboot my computer. I don't know. Yeah, Diz, why don't you drive? I'm gonna try to reboot my computer and see if that handles it. So Dizzy, you take the wheel. Um and I should be back in like a few minutes. Right? Hopefully it resolves it.
Good morning, sir. Are you Mr. Colin Gray? Am I pronouncing your first name correctly? Mr. Gray, my name is Curry Mingledorf. I'm assigned to preside over this morning's proceeding. This is your first appearance hearing. And at this hearing, I'm first going to ask you just a few questions, and then I'm going to advise you of your rights and also let you know about a preliminary hearing that's been scheduled for you. Why don't you just state your name, please? All right, pull the microphone down, please. There you go. All right, and how old are you, Mr. Gray?
54.
And are you able to read and write and understand the English language without
Yes,
any
sir.
difficulty?
Yes, sir.
How far did you go in school?
11th grade GED.
Okay. And I note that you have counsel seated with you at the table. Do you understand that you have the right to be represented by an attorney at all times for this and all future proceedings in your case?
Yes, sir.
And do you understand that, of course, if you cannot afford an attorney, that the public defender will be appointed to represent you upon your request?
Yes, sir.
All right. And counsel, would you identify yourself, please, for the record?
Donna Seagraves. We are going to have new counsel assigned to Mr. Gray later today.
All right. Thank you. All right. Okay. Sorry. Just need to make sure that the system is working. And all right. So the following aren't questions that I'm going to ask. I'm just informing you of some things. You have the right to remain silent. Anything you say can be used against you at further hearings or at a trial on the charges that you're facing. For this hearing, you're not going to be questioned about facts and circumstances surrounding your charges. You are currently charged with, and you'll be provided with copies of the warrants if you don't already have them. You're currently charged with 2 counts of felony murder in the second degree. You're charged with 4 counts of felony involuntary manslaughter. You're charged with 8 counts of felony cruelty to children in the second degree. Now, for these offenses, for the felony murder counts in the second degree, felony murder in the second degree, the maximum penalty for each count is up to 30 years imprisonment. For felony involuntary manslaughter, of course, again, there are 4 counts. The maximum penalty for each of those offenses is 10 years imprisonment. For the 8 felony cruelty to children counts, the maximum penalty under the law for each of those 8 counts is 10 years imprisonment, for a maximum total possible penalty for the charges that you currently are facing of 180 years imprisonment. If you have questions about these charges, which I assume that you will, the court urges you to discuss those with your attorney. Let me inquire as to whether there's a motion for bond if Mr. Gray is moving for bond at this time.
No, sir, not at this time. We will allow alternate counsel to make that decision.
All right, thank you. I also need to inform you that you have the right to an indictment by a grand jury, and you also have the right to a preliminary hearing unless you make bond or waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. I want to make it clear to you, Mr. Gray, that you are presumed innocent. Your refusal to testify at any point will not, cannot be used against you in determining whether you are guilty or not guilty. I mentioned the first appearance hearing a moment ago. That is being set for you for December 4th, 2024 at 8:30 a.m. Currently, that's set to take place in the Magistrate Court of Barrow County. It could be subject to change, but I just want you to know that that is the date that we currently have. In fact, counsel, could you approach, please? I have this, let's see, I need to scratch this out. This document that discusses bond and gives the date of the preliminary hearing, and I guess I could sign that, and then he can just get a copy of it. And then the warrants are attached to that. So
That dude's feeling all of it today.
him,
Feeling all of it.
please.
Right there, just so you're getting a copy of this. He is giving you a copy. He'll give you a copy of all the warrants.
Do you want me to go ahead and give him his copy?
Yes, please.
And the page continues. So you're all put on the first one.
And are these his copies of the warrants?
Those are provided, and they say service copies on them, so I assume that they're for him. Sergeant Briscoe, do you concur with that? Is that what those copies are for?
That's detention center.
Those are for the detention center? So he's got his own copies, or he'll have them provided? All right, so the detention center wants to hold on to those. All right, let me, and thank you, Ms. Seagraves. I want to certainly acknowledge the presence of our district attorney, Mr. Brad Smith. He's assisted by his chief assistant, Patricia Brooks. Is there anything else, counsel, that the court needs to address that I have neglected to address?
No, Your Honor.
No, sir, not at this time.
All right. I do want to thank those who are in the gallery who have an interest and who have appeared. I appreciate the decorum that has been maintained throughout this proceeding, or both of these proceedings today. And with that, this matter is adjourned.
All right. So that was him being arraigned this morning, his first court appearance. What I want to do now, I'm going to give you all a little bit of a primer on what went down. Dizzy, I want to acknowledge the victims first. I don't know if you were able to, let me pull this up. I have to admit, I hate the Daily Mail, but sometimes their articles have the most stuff. All right, so these are the 4 victims. You're gonna have to try to block out all the nightmarish ads on each side here. So you've got 14-year-old Mason Schermerhorn, an autistic student at Apalachee High School. He was the first victim to be identified. Additionally, another 14-year-old Christian Angulo lost his life as well. And then we had 2 teachers who had given, their lives to teach our youth. And so teacher Richard Aspinwall, he was named one of the 4 victims, and I'm sure I'm going to butcher her name, which I don't want to do. Christina Remy, I want to say, was the second teacher victim. So 4 victims total in what had to have been just another absolute nightmare. I like these school shootings. I'm just, I'm so beyond. I'm like, I cannot stomach them anymore. Um, I don't even want to show the kid's face. Which makes these things, these cases, like you see with most of these kids, they're so troubled, and it comes out how troubled they were. And I had a very firm position with respect to Ethan Crumbly and his parents, who were both charged and convicted, rightfully so, in my opinion. But what made the Crumbly case so interesting, why I wanted to cover that case, why I did cover that case, and which I kept telling people that if they are convicted, every prosecutor's office in the country now will feel like they have the ability to be able to bring cases where parents are being held criminally responsible for the atrocious acts that their kids are committing in these school shootings. And I realize it is a hot potato in terms of people's views on this. I understand it. I understand that people are, you got and there's so many things intertwined with these cases, Second Amendment, gun reform, the politics of it. And, uh, and I get it. And I understand why people are concerned about it. Um, I'm just not hearing it. Enough is enough. And I said it flat out. Like, I called this 100%, and I'm not sitting here patting myself on the back. My hope is that, maybe people out there are going to start getting the message. Parents out there are going to start getting the message that you have to be present in your children's lives. This walking around oblivious as to what the hell's going on in your kids' lives is not going to stand anymore. We do not live in that society anymore. That ship has long sailed. We now live in a hyper violent, incredibly damaging mental and physical well-being environment where kids are just being bombarded with everything. And I mean, I'll flat out tell you, in my estimation, the internet, social media plays a huge part in this, just destroying the fabric of young people's lives in ways that just didn't exist when I was a kid. Just did not exist. When you look at the things that have changed post Columbine, which went down like right when I was getting out of high school, and you look at the amount of school shootings that have occurred in this country, and this is a distinctly American problem. It's not to say that it hasn't happened in other countries, but nowhere on the planet has the issue like we have. So you've got to try to figure out what is the root cause, or what are the root causes of this. And I want to kind of go through I posted this yesterday. I gifted the article. I mean, still the New York Times is probably the most credible print media in my estimation these days. Everything is hot garbage out there. But in terms of, maybe having a semblance of journalistic integrity, I think that the Times is probably still right around the top of the list. So I just want to give like some of the background, and then I'm going to briefly go into this concept of parents now being charged for the actions of their children in terms of these school shootings. And like in Crumbly, I was very vocal that I was in support of the state bringing these charges. I was in support of the jury of that community coming back and finding the Crumbleys guilty in 2 separate trials, because you know what? They were. They failed that community. They failed their child. They failed everybody by being oblivious to what was going on in their child's life. Like if and in that case, we had, for me, what was the definitive piece of evidence was the math test or the math quiz that Ethan went into class, drew the pictures of somebody lying shot with blood spilling out, just the haunting words, "I can't stop the thoughts, help me," knowing that he's turning that into his teacher, and that ultimately he'd get called down to the principal's office, which happened. His parents sit in the meeting with the counselor, the principal, and the 2 parents, and Ethan. And collectively, this kid who's like literally begging for help the day of the shooting. I mean, if the words "help me" aren't clear enough for you, then you need to work on your reading and your reading comprehension, because that's as clear as you can get. If any of my kids ever wrote those 2 words on a piece of paper and I got my hands on it or they gave it to me, you bet your ass I'm helping my kids. I'm doing everything in my power to find out what is going on with my child or my children. It's like, there's no flexibility for me on that. I hold people at the same standard that I hold myself in terms of being a parent, to being present in my kids' lives, to making sure that they know on a daily basis ad nauseum that I love them, that I'm here for them for no matter what it is, that I'm not sitting here in judgment of them ever, that I'm here to support them in any way possible. My kids know that definitively. Like I pride my life on that. My kids are my life. And, the problem is in this country and really the world at large is any asshole can become a parent. It's that simple. We have to get licenses for all kinds of other stuff, to drive, to own guns. Any old asshole can become a parent. That's the sad reality of it. And when you have asshole parents who are so wrapped up in their own shit that they are oblivious to what is going on in their kids' lives, and their kid is then either given a weapon as a gift. This kid's 14. And I don't know, like I'm hearing varying stories that he got an AR-15, a 14-year-old got an AR-15 for Christmas, or it was in the house and he had access to it. Either way is completely and totally unacceptable. Because when you compound the fact that you're ignoring everything that's going on in your kid's life, and then you're giving that child access to a deadly weapon, and then they go and do this, you're on the hook, sucker. That's it. Like, and no one is ever changing my mind on it. Like, is it a slippery slope? Yeah, it is. Yeah, it is. And I've had interesting questions. It's a debate, and I do want to get Josh Schiffer on here, because out of like all my lawyer buddies, like I love Josh, and he'll be super thoughtful. Like, I think we'll have an amazing conversation about this. But as far as I'm concerned, because it's going to start coming out, we're going to start seeing the writings that were in his room. So I want to read through this article a bit, just so you guys can get a background on what led up to this nightmare, the most recent nightmare. And so Colin Gray, and that's the defendant that we just saw in court, the father of the 14-year-old accused of killing 2 teachers and 2 students at his Georgia high school, was arrested and charged on Thursday with second-degree murder. That's different and Dizzy sent me the arrest warrants, and they're brief in terms of the affidavit in support of the arrest warrants, but I'm going to pull them up after I read through this. The Crumbleys were not charged with second-degree murder. Like, Georgia is up in the game. So they charged with second-degree murder in connection with the state's deadliest school shooting, the Georgia Bureau of Investigation said. In addition to 2 counts of second-degree murder, Mr. Gray was also charged with 4 counts of involuntary manslaughter and 8 counts of cruelty to children, according to the statement. At a news conference on Thursday night, Chris Hosey, GBI director, said that the charges were, quote, directly connected with the actions of his son and allowing him to possess a weapon, end quote. He declined to offer much more detail other than to note that Mr. Gray was in custody. The arrest came after new details emerged on Thursday about the teenage suspect's interest in previous massacres and his father's ownership of several guns, including a military-style rifle like the one used in the attack. 2 family members told the New York Times that the youth, who had been charged with 4 counts of felony murder, had a troubled home life. My grandson, this is a quote from his grandfather, my grandson did what he did because of the environment he lived in, end quote, said his grandfather, Charles Polhamus. An aunt, Annie Brown, texted, quote, the adults in his life let him down. There were also growing questions about potentially missed opportunities to prevent the attack. School officers interviewed the teenager over a year ago about how school shooting threats made on social media, but found no definitive evidence that the boy had posted the message. And we're talking about this on a Discord server, according to an investigative report obtained by the Times. I want to see if I can pull this link up. All right, so this story, which I'm pulling up now, is linked in that story. And this, let's see if this pulls up this. Okay. All right. So this was September 5th, 2024. This obviously popped out right after. So a report details the investigation of the Georgia suspect in a prior school shooting threat. Because again, remember, the thing that in my estimation puts these parents on the hook is notice that they knew or they should have known. If they didn't have their head firmly jammed all the way up their ass, they'd know what was going on in their kids' lives. Crumley, it was the text messages between Ethan and his mother, Jennifer, and, her saying, oh, all my son's issues are related to the fact that he, thinks that there's a ghost in the house. He's saying, he's texting that the demon's back and it's throwing and smashing plates, and the kid's obviously disturbed, and she's talking about some kind of Ouija board bullshit and ghosts in the basement in their haunted house. And then they sit in that room and then they get that test and they make the decision to leave their kid at school. I don't give a shit what the school said. I'm never leaving my kid in the school that day if I'm handed that test and I see that my child is in distress like that. And if you're of the mindset that you would, well, shame on you. Because this is what happens repeatedly. So this story, the anonymous tips that were sent to the FBI last May from as far as away from Australia, warning that a user on Discord, a social media platform, had threatened in chat to possibly, quote, shoot up a middle school, end quote. The authorities were led to a 13-year-old living in Jackson County, Georgia. A report from the Jackson County Sheriff's Office obtained by the New York Times detailed how investigators looked into but were unable to definitively link those threats to the teen, who is now in custody after a shooting on Wednesday morning at his high school in Winder, Georgia. He is accused of killing 2 students and 2 teachers. Police found evidence that the 14-year-old suspect had an interest in mass shootings during a search of his room on Wednesday. According to two law enforcement officials briefed on the investigation, he appeared to be particularly obsessed, they say, with the 2018 massacre at Stoneman Douglas High School in Parkland, Florida, that killed 17 people. Sheriff Janice Magnum of Jackson County, Georgia, said in an interview that her agency had taken the 2023 investigation into online threats, which led them to the accused shooter as far as possible. It's not like we didn't investigate it, Magnum said, adding, I'm broken to think about what happened yesterday. That could have been any school. So, it looks like these are tweets. This is the same thing. Now, this story, I've seen another report where they said that they were able to, how they figured out that it was coming from that house was by an email that was used for the profile, to create the profile on the Discord. And that email was connected to this kid. And apparently they didn't think that that was enough. Apparently they did not think that that was enough. It just blows my mind. All right. So the other thing, because the question becomes like the parents that are resistant to being held accountable for their children's actions in situations like this, like to point the finger at the schools. And the schools, in my estimation, are absolutely accountable as well. Problem is that schools are not human beings. They are institutions. You cannot arrest institutions. You can sue institutions. The problem with suing institutions that are government owned is that they have governmental immunity. And it is very difficult to recover from any kind of government entity. It's not to say that it can't be done. I mean, they definitely sued the school in the Crumley case. I forget what the name of the school is, up in Michigan, but those were booted because they were immune. But the question becomes in this case is how in the hell does this kid walk into a school in this day and age with an AR-15? Now, I don't know much. And I'll be the first to admit I do not know anything about AR-15s. I do not know how they break down. I do not know how compact you can make them in terms of traveling with them. But in this day and age, to think that that kid made it into that school with that weapon blows my mind. Just absolutely blows my mind. It's like really, really hard for me to stomach that. So ultimately, the victims, again, Mason, Christian, the two 14-year-olds, one of them, a sweet autistic kid, were killed along with the two teachers, Christina and Richard. 9 other people were hospitalized with injuries. I mean, this is like a nightmare scenario. I can't even imagine me being in a school or a market or anywhere, a mall, anywhere, and having this go down, and to think of my children, my little girl Scout, who, you guys, if you follow this channel, the thought of her being involved in this just crumbles my heart. It's horrifying. This did not exist when I was a kid. We have gone off the rails. This country has gone off the rails to the extent where this is the end result. This is what needs to be happening. And I will debate anybody on it. I don't care where they're from. I don't care what their politics are. There is no other response to this than other than to hold parents responsible. You've got to be in tune with what's going on with your children. And I get it. I've raised two now fully grown adult children. Cameron's 18 and Scarlett is 12. And I know how difficult it is to be able to connect with your teenagers. I get it. I get it. But this shit's a whole different thing. These kids are reaching out. These kids reached out to people. They reached out to family. And it went ignored. And then you turn around after the feds have been to your house, or if it wasn't the feds, it was the feds that gave the tip and the GBIs at your house, or the county sheriff is at your house telling you, hey, it appears that your son is on a online service that is, and he's threatening to shoot up a middle school. Whether they arrest somebody or not, or whether they continue the investigation, or if that's not enough of a hint, and for the parents to say, Jesus, what's going on with my kid? I need to figure out what's going on with my kid. Then I can't help you. Then you need to put your kids up for adoption and let people that are actively wanting to raise children, to get children into their lives that are going to do what they need to do as parents, give somebody else the chance to give your child a chance in a life. Because it's like there's no excuse for me in terms of what people are going to come at me with this. Like it's falling on deaf ears. It's just this isn't you're getting arrested if your kid goes into a store and shoplifts. This isn't that. Don't confuse what this is. This is when your kid goes and shoots up a school and they come to investigate and they find out that had you done anything, any kind of parenting whatsoever that you would have known, I hold you responsible. The states are now going to start holding you responsible. The parents of those victims hold you responsible. The loved ones of those victims hold you responsible. And you know what? You are. And this is just the beginning. I warned people. Like I said, this is it. Crumbly just set the precedent. The precedent is in stone. Every prosecutor's office, just go back. Go back, watch my Crumbly. Like I said it in like I don't know. It's like it's just like it's patently obvious that once one prosecutor's office had the guts to try to bring some parents to justice that allowed their kid to do this. And when I say allowed, yes, they allowed it. I mean, like it was coming and it's here. And I can only hope what the hope is. Is it going to be a deterrent? I don't know. Like I'm of the mindset that the death penalty has never deterred one killer from doing anything. That if you've got murder on your mind, that's it. Like you're not going to be sitting there and contemplating, oh, well, if I do this, I'm going to probably get the death penalty. You're not thinking in terms of that. This is different than that. Because the parents aren't the ones pulling the trigger. So as parents out here in this country start to see parents going to prison for the rest of their lives in some cases, maybe they're going to think about buying their kid. Like, don't buy your kid that's 14 an AR-15. Okay, start there. Don't do that. If you're going to have guns, and I know that people that are gun owners are always preaching about gun safety, yet it seems to slip through the cracks, doesn't it? Yet kids are somehow still getting their hands on the guns, aren't they? So I don't know that that's the answer. This isn't a gun safety issue for me. This isn't that it wasn't in a locked gun box or gun safe. This isn't about that. It goes deeper than that. This is a fundamental question about whether or not, as a country, we're going to put our feet down and say, you know what, this is it. Like, we're done having our kids getting massacred in these schools, and we're just trying to get them out there to learn in order for them to become productive members of society. Like, I'm done sending my kid into a potential, like, hellhole, shot up school nightmare. Like, I mean, at what point like, is the next step that we just go straight online learning, that we make schools a thing of the past? Is that our answer? We desocialize our kids and shut down schools and destroy the fabric of their lives in that way so that they can't learn how to socialize, how to interact in the real world. I mean, is that where we're heading? I mean, like these cases to me are the last line of defense in terms of us living in a world like that. I don't want to live in a world like that. I really don't. You know, like, I love Jay with all my heart. He's a homebody. I know a lot of our fam are homebodies. Like, in terms of being out in the real world, like, I don't want my kids to be afraid to step foot out of the house. Now, if their personality is such as that they're a homebody, good on them. That's them, you know. But I don't want it to be because they're afraid. It's one thing to make a decision based on, I'm not comfortable in social situations. I'm an introverted person. That's a whole different thing than being terrified to step foot out of your house. I don't want it to be where I can't send my kids to school. My kid Scarlett loves going to school. She loves seeing her friends every day, loves it. She loves playing sports. She loves interacting. And I would never want to rob her of that. So what happened yesterday, which is a direct link to Crumley, because I'm telling you, these cases are on all fours, meaning that they're damn near the exact same fact pattern. So, yeah, I'm sorry, all this thing just gets me like that. I cannot with this shit. I cannot. Like, I'm beyond it. Yeah. And again, like, it raises so many questions, and I said it is a slippery slope, meaning that you start charging parents, like, where does it end? Where, what are the limitations of it? Like, how remote does it have to be in order for the state to say, you know what? And I'm talking about in terms of having knowledge of what's going on with your kid. Like what is the line? And it's super blurry right now, but that's how the law works. That gets developed by trying the cases. We will find out where that line is as these cases get tried, as juries make the decision. Us, the citizens, will make the decisions in these courtrooms all across the country when these defendants are answering the charges in courts of law. The juries will say, you know what? That's not enough. In this case, you gave me a certain amount of evidence. I just can't in good conscience say I'm holding those parents responsible because it wasn't enough. Like, that could be me. And we're like, every juror in that room that's a parent is going to be putting themselves in the shoes of that defendant and being like, wow, if this was me, like, that will always be the lens that they're processing things through. And it should be. It should be. I mean, what we don't want is this to become like a political thing where it's the NRA is in there lobbying. Like, this is about the lives of our children. There's nothing more precious than that. Nothing. like to me with this thing, the disturbing things are obviously, and again, we're one day out from this thing, and we already know that we've got aunts and grandfathers saying that this kid was troubled, that this kid was begging for help, and we're gonna see it. Like the evidence is going to be there. Like when they come at him with the second-degree murder charge, that's saying something because that's up in the game. Like that upped the game from the Crumbly thing from, which I believe there was voluntary manslaughter. So it's a whole different thing. So, all right, let me see my Dizzy, my Adobe was updating when I rebooted my computer. Let me see if I can open up what Diz sent me. I want to just look at the charges real quickly. And then, unfortunately, I wasted way more time than I thought. I've been on here 2 hours. What I think I'm going to do with Shaver, because I got to go record at 3:00. So I've got a few minutes left. And then, but I want to do Shaver because Mandy did work behind the scenes. And as always, Dizzy did work. And we're going to cover it. So I'm going to see what's up. I don't know if Jay's going live. I know the boys are doing Feral Friday tonight, Publicly Buzzed. So I might try to slip in an hour tonight because I want to give you guys the background on Laurie Shaver. And I want to go and review that hearing that they just had recently in that case before we start it. So let me see if I can pull these up, unless you've got them, Diz. If you could pull up just I just want to look at one of each, the murder, the second-degree murder, as well as, because like I don't know that I want to be able to open my Acrobat. Like it's been updating for, I don't know, 20 minutes, which seems weird. Can you get it, Diz? All right. Let's see. Yeah, I can't with these cases, man. Oh, like they get to me hard. It's such a fundamental thing for our country that I don't know. What are y'all saying in chat? I haven't even looked. I'll look after the fact, see what y'all are saying. Yeah, and I'm not afraid to step on toes on this issue. Just not even a little bit. All right, let me see. All right, so Dizzy sent this here. Let me see if I can get this open. Oh my God, it's still installing. Yeah, like something's like the whole reset. Oh, there we go. Finally. Okay. I got it, Diz. All right. I'm going to pull this bad boy up right here. Stop the screen. We go right here. All right. So, like, these are going to be very short affidavits. This isn't going to be Hewerman bail applications. These are kind of just breaking down. So again, he's been charged with a whole bunch. And as you saw in that hearing, he is staring dead in the face, 180 years potentially in penalties. So this is for the arrest warrant for the second-degree murder. Okay, and this is the way the affidavit reads. Personally, Kim Kelsey Ward on oath says that to the best of the affiant's knowledge and belief that Colin Gray did in the county and state of the aforesaid commit the offense of 16-5-1D, felony murder in the second degree, to wit, did willingly and knowingly while in the commission of cruelty to children in the second degree. Colin Gray did cause the death, and then obviously of a child under the age of 18 years, irrespective of malice, by providing a firearm to Colt Gray with knowledge that he was a threat to himself and others between the dates of 9/4/2024 at 10 a.m. and 9/4/2024 at 11 a.m. in Barrow County, Georgia, the place of occurrence of said offense being on the address of the school. So that's for the second degree. Got 2 of those. This is the involuntary. So that's what they have to show. Like those are the elements of the statute. So they break those down. So ultimately they're going to have to show that he had knowledge, which again, they searched the kid's room. And it's going to be an issue of known or should have known when it comes to trial. So this is the affidavit again for, I believe this is going to be for the involuntary. This is the felony involuntary manslaughter. All right. So again, Kelsey Ward came in the county and state aforesaid, committed the offense of 16-5-3A, felony involuntary manslaughter to wit, did willingly and knowingly while in the commission of a reckless conduct, an unlawful act. Colin Gray did cause the death of the teachers. This is Richard Aspinwall without any hesitation or without any intention to do so by providing a firearm to Colt Gray with knowledge that he was a threat to himself and others. And again, the dates. So you can see that knowledge aspect is going to be a big issue again. And that's always going to be the challenges in these cases. That's going to be the challenges. That is what separates these from every other type of case that parents out there are concerned that they could be charged with. If their kids break a window at somebody's house or if their kids rob a house, can I be charged with that? No, you can't. Unless, of course, your kid has the blueprints of a robbery sitting on his desk in his bedroom. And he's told you 3 times, boy, I really think that robberies are pretty interesting. Thinking about, it's all about knowledge. It's about what you know or what you should know. That's where the responsibility is going to lay here. And these cases may make it all the way up to the Supreme Court eventually. These are going to be cases that are going to be litigated. They're going to be appealed. They're going to make their way up the system. That is how we create law in this country. I told you, if you watch the channel, statutes are just written by legislators. They're House bills, and then they're voted on, and they make it through the House and the Senate, and then either, the president of the United States writes, signs off, and it becomes federal law. It's the governor if it's state law, and then the thing is put into the world, and then lawyers argue about what the statute means, how it applies to us, how it applies in the law. And that's what we do as lawyers. That's how we figure out how the law applies. It's one thing to write a bunch of words on a piece of paper. It's another thing to see how it operates in practice. And that's really what lawyers do. Lawyers, you always have 2 sides that are looking at the exact same things with very, very different interpretations. That's what I'm always saying. The practice of law is really a matter of interpretation. All right. So now I want to get down to, so we've got the multiple counts of cruelty to children. And so this is the way that affidavit reads. And again, it was Kelsey Ward in there. She was going and getting the warrants. Wait, that looks like it's still manslaughter. Okay. All right. So, to the best of the affiant's knowledge and belief that Colin Gray did in the county and the state of the aforesaid commit the offenses of 16-5-70, felony cruelty to children, second degree, to wit, did willingly and knowingly. Colin Gray did, with criminal negligence, cause blank, a child under the age of 18 years, cruel and excessive physical pain by providing a firearm to Colt Gray with knowledge that he was a threat to himself and others between the dates of 9/4 of 2024 at the aforementioned time. So there you go. So there's 8 of those. So pretty bare bone. But as this thing progresses, we're going to start hearing more. It's going to start coming out. We're going to start seeing what's what in terms of what was going on with this kid, who knew what, who should have known what. But when his grandfather and his aunt are already out basically flame throwing this guy, saying, and like I haven't even gotten into it, like the thing that's going on with mom, Macy Gray. And I'm not talking about good Macy Gray, the amazing singer who I love. I'm talking about this kid's mother, who had some issues. Sounded like she had addiction issues. She was deep in it. All right, so I got a few questions here I want to answer before I bounce. Lisa, Defense Diaries, do you think the enough to detain someone for threats could change for something like this? I mean, look, I think them making the connection that it's his email was probably enough for them to have invested the time, because basically his excuse was that he's been hacked. So, I mean, they know it's coming from his IP address. They know it's coming from his email account. Like it seems that there could have been a way if they put in a little more. I mean, like they're going to take shit for it. Like that sheriff's office is going to take a bunch of heat for this, that this should have been stopped at that point. But then again, when they walk out that door, dad has to take control of the situation. Dad has to father his son. Dad has to find out what is going on with his boy. And he didn't do that. What he did is he decided to buy him an AR-15. Katie. Kitty C313, mental health evaluations need to be easily available to all persons in the community. 100%, in my opinion, 100%. If a child is in crisis, homeschool options are available until they are well again. Absolutely. Could not agree more. Like this would be a 50-hour live if we started trying to delve into the societal ills that are causing these things to happen. I mean, it's never ending. I mean, it's never ending to get into the lack of mental health care in this country, the difficulty in getting that help is a whole nother issue. Kraken, not a gun issue, not a mental health issue. This is adults needing to make and demand changes. I agree. And parents need to parent. You're on the hook. You're going to have kids. You're on the hook in my book. Tracy, you're here. Happy birthday, Tracy K. Such a happy occasion to talk about such shitty, miserable things. But happy birthday, Tracy. We all love you. We adore you. I thank you for everything that you do. Everything. Your modding, amazing work that you do with Dizzy, seeking justice. And I hope that you have a glorious weekend where everybody in your life just celebrates the hell out of you. I hope that is your day. All right, you guys. So I promise I will be back tonight. I'm going to try to get back early. I'm going to peek at Jay's channel, see if Jay has anything going on. If not, I want to come in for about an hour. I want to do the Shaver thing because I do anticipate covering that trial next week. The Shaver thing, it's a crazy, crazy case. My friend, Brandy Churchwell, she's got a really weird, close connection with that case. She's going to be boots on the ground there. I was texting her. She's going to be kind enough to hop on with us a couple of times. She's streaming it on her channel. Somebody's going to be babysitting for her over there. But I asked her if she'd come on, give us some live boots on the ground updates from the courtroom. Well, obviously outside the courtroom, but in the courthouse. And she said she'd do that. So that'll be interesting. So, sorry, I'm passionate about this one, y'all. If you're on the opposite side of it, sorry, but not sorry. I feel the way I feel, and you are allowed absolutely disagree with me. And, but it's someday, at some point, enough is enough. Like at some point, like every person in this country has to say enough is enough. And like, God forbid it's ever one of your kids that's what it takes for you to be like, enough is enough. I wouldn't wish that on my worst enemy ever. So, but like, just, it's time, folks, and it's coming. It is coming. It is here. So, all right, y'all, as always, thank you for the support financially. Thank you for the emotional support that you guys always give me. Thank you for listening to me rant for the last hour. And I will see you on the flip side. Hit your notifications, please. That way you'll find out about Shaver. You're going to want to hang. You're going to want to see that one tonight to prepare for this trial. And again, like, don't cheat. Don't look. Because like, if you don't know anything about that case and you know who this woman ends up pointing the finger at in terms of killing her husband, it's going to shock you. It's going to just shock you. It's unbelievable. We just live in the most warped world of all time. All right, you guys are amazing. I love you all. And just remember, without y'all, I am just an old man talking about a whole bunch of cases. See you in a bit.